is this, my lord. What did they challenge in section 34, my lord? There were basically three grounds, my lord. One was limitation. Second, they say it is not, the award has not been signed on all pages by the arbitrators. And third is appreciation of evidence. So, my lord, when they, after this order, my lord, what limitation part, then they argued the main part before your lordship's court, my lord. And then the order was passed by the addressing the last sentence.
Does the text of the judgment of the Supreme Court indicate that there is any finding on merits?
No, my lord, would your lordship see the award? Why did your lordships? Why?
Sir, let's not labor the point too much. I mean, if the judgment of our court doesn't consider it, does not make any finding on merits.
In fact, your lordship's judgment says solely.
Mr. Hansaria.
Yes, my lord.
At the end of it, you may still succeed before the High Court in his challenge because the challenge is very limited. You can tell the High Court that.
Just show his conduct twice, my lord. Two things. My lord, there's one section 34 order in which the three grounds, my lord, I have said to your lordships. He filed two separate independent appeals, my lord, under section 37.
One against the rejection
no,
of...
there is one common award, common section 34.
You can argue all that.
That shows the conduct, Lord. Second matter, he does not show before the court. Otherwise, Lord, both there are two section 37 he files. They are kept separately. Second one is kept behind, Lord, before another bench. They don't hear it.
No problem. If you are going through the judgment,
I'm so sorry, Lord.
it's very evident that this court considered only on the question of limitation.
Lord,
With respect to the other aspects, if at all they are available, legally available for them.
No, my lord,
So there was absolutely no observation, there was no discussion, absolutely nothing.
my lord, there is no discussion in the, my lord, but then it was, my lord, which was, I would say, my lord, I was there, my lord, I can't say, my lips were there, but I
court is not
that even, my lord, can I just submit some respect?
Mr. Hansaria.
Yeah, my lord.
We will protect your client because in all probability, you may be able to persuade the High Court that there is no merit in his challenge.
Please, Lord, sir.
But argue it before the High Court.
May I just,
you can't shut out a party.
I see, my lord, what is following from the court. Can I just say two things, my lord? It is an award of 2019. 2022, it has been confirmed by the trial court. They have not deposited. Let them, the so bona fide, let them deposit the decretal amount in the High Court.
But you execute the award.
No, my lord, in execution, size it has to come, my lord, before the High Court and before this honorable court. After this, I went for execution. All that I'm
You have to make a stateable point.
No.
You execute the award.
No, Lord,
there is no stay on the award.
No, my lord, that's what I'm saying, my lord. There was no stay on the award.
Right, so you execute the award.
Then, my lord, against the rejection of the stay, they went to the High Court. High Court said stay, my lord, it was, some orders were passed. I came to your lordship's court. Lordship said there is no stay. The stay application has been rejected finally by the High Court, my lord. But then, my lord, they say now it is pending. Now they will say, my lord, what is the difficulty, my lord?
We will
Decretal money in the High Court.
We will.
I'm not saying.
Mr. Hansaria.
Yes.
If there is no stay.
Yes, my lord.
Admittedly, there is no stay on the award.
Yes, my lord.
We'll make one observation that you can execute the award if there is no stay.
Your lordship may not say that for one reason, that against that, as Mr. Ansari correctly said, we went to the High Court. The High Court notes the fact that your lordships were not made aware of two things. One, that there was another appeal pending, as a result of which that sentence would cause us prejudice. High Court notes that. As a result of which, if anything, your lordship says regarding those proceedings will really affect us.
Well, all that I'm saying, well, let them deposit.
The review petition, 1 second.
Only one.
The review, no.
Direct
You have a whole board now, 1 second.
To decide within a 2 months.
All right, that will do.
Yes.
The review petition arises out of an arbitration between the appellant and the respondent. Full stop. Before the arbitral tribunal, the review petitioner was the claimant, while the respondent was filed a counterclaim. While the respondent had filed a counterclaim as well. Full stop. The arbitral award partly allowed the claim. If there's any error, please correct us while dictation. The arbitral award partially allowed the claim of the review petitioner and allowed the counterclaim of the respondent in its entirety. Full stop. The review petitioner filed 2 petitions under Section 34 of the Arbitration and Conciliation Act 1996, challenging bracket 1, the award of the counterclaims, semicolon, and bracket 2, the partial rejection of its claims. Full stop. By a common order, the learned district judge upheld the award, rejecting each of the contentions of the review petitioners, including the argument that the counterclaim was barred by limitation. Full stop. Notably, limitation, the issue of limitation was one of the contentions raised by the review petitioner and rejected by the district judge at that stage. Full stop. The review petitioner filed arbitration appeal number 26 of 2022 before the Odisha High Court under section 37, challenging the award of the counterclaim. Full stop. In addition to the argument that the counterclaim was barred by limitation, the petitioner raised other grounds, including those pertaining to the interpretation of various clauses of the contract, the failure to consider the assessment of independent experts, and in regard to the framing of issues. Full stop. The petitioner also filed a separate appeal, arbitration appeal 28 of 2022, challenging the partial rejection of its claims in the award. Full stop. In the underlying appeal, which gave rise to the proceedings before this court, the Odisha High Court set aside the order of the district judge and the award on the sole ground that the counterclaim was barred by limitation. Full stop. The order of the judgment of the Odisha High Court came to be questioned before this court in proceedings under Article 136 of the Constitution. Full stop. By its judgment dated, what is the date of our judgment?
24th April 2023.
April 23.
By a judgment dated 24 April 2023, a bench of two learned judges of this court, consisting of Honorable Mr. Justice M.R. Shah and one of us, into brackets, Honorable Mr. Justice C.T. Ravikumar, set aside the High Court judgment. Full stop. Set aside the High Court judgment and came to the conclusion that the counterclaim was not barred by limitation. Full stop. No other issue, admittedly, no other issue apart from the claim of limitation was dealt with in the judgment of this court. Full stop. However, the judgment of this court restored the award of the arbitral tribunal in its entirety. Full stop. The restoration of the award has given rise to the review petition. Full stop. The review petitioner next moved an application before the High Court for the revival of the underlying appeal for adjudication of the remaining grounds, except the issue of limitation, which was settled by the judgment of this court. Full stop. The High Court dismissed the application for revival on the ground that the judgment of this court did not bifurcate the contentions of the review petitioner separately and had restored the award in its entirety. Full stop. The review petitioner filed a miscellaneous application before this court seeking modification of the order to the extent that the other grounds raised in the underlying appeal were open for adjudication. Full stop. The miscellaneous application was dismissed by a two-judge bench consisting of Honorable Mr. Justice Sanjay Kumar and Honorable Mr. Justice C.T. Ravi Kumar on the ground that the petitioner was essentially seeking a review of the judgment. Full stop. Separately, the petitioner also filed a special petition against the judgment of the High Court dismissing the revival application. Full stop. The special petition was dismissed as withdrawn, recording the statement of the petitioner that the petitioner would seek a review of the judgment of this court. Full stop. A review petition has accordingly been filed. Next. And the above, we have heard Mr. Gopal Shankar Narayan, then senior counsel, appearing on behalf of the appellant of the review petitioner, and Mr. Vijay Hansaria, learned senior counsel for the respondent. Full stop. The narration of facts above would indicate that the the sole issue which was dealt with in the judgment of this court pertained to the question as to whether the counterclaim of the respondent was barred by limitation. Full stop. Plainly, this court came to the conclusion that the counterclaim was not barred by limitation. Full stop. That has attained finality, and we clarify that we are not disturbing that finding in the exercise of the review jurisdiction. Full stop. However, having come to the conclusion that the counterclaim was not barred by limitation, it was only appropriate and proper that the proceedings should be remanded back to the High Court for resolving any other challenges to the allowing of the counterclaim, save and except the issue of limitation which stands concluded. Full stop. Likewise, the appeal which has been filed under Section 37 by the review petitioner, challenging the partial rejection of its claims, is also pending before the Odisha High Court. Full stop. Therefore, in the exercise of the review jurisdiction, a limited relief would be warranted in the interests of justice, in the absence of which, all challenges of the review petitioner independently on issues which have not been dealt with thus far would stand concluded. Would stop. We accordingly clarify that the observation in the judgment of this court dated so and so that the arbitral award is restored shall stand recalled and be substituted by the direction to the effect that that all other contentions which may be admissible in law to the review petitioner, all other contentions which may be admissible in law to the contesting parties may appropriately be raised before and considered by the High Court. Full stop.
Both petitions may be heard together, my lord.
We have no objection to that.
Both the arbitration appeals,
Your Lordship may specify 26 of 22 and 28 of 22.
namely arbitration appeal 26 of 2022 and arbitration appeal 28 of 2022, may be conveniently heard by one and the same bench and the learned Chief Justice of the High Court of Odisha may be moved for administrative directions
No, Lord.
in that regard.
No, Lordship, say, my lord, it may be decided because, my lord, the decree is of 1919, my lord.
The
The
decree
award is of
is-
1919.
Yeah.
I haven't got a single penny, my
The
lord.
arbitral award pertains to 2019. We would request the learned Chief Justice of the High Court to assign both the arbitration appeals to any bench on the with an administrative direction, and we request the High Court to take up both the appeals expeditiously for final disposal, preferably within a period of
3 months, my lord.
3
Lord, would,
months from the date of receipt of a certified copy of this order.
Lordship may clarify there is no stay, my lord. Because otherwise, my lord, what has been happening is, my lord, even after the dismissal, my lord.
Sir, he doesn't dispute it. You execute the award.
No, my lord, my lord, I have gone, my lord, the executing the award. They say there is a stay. Then, my lord, I come and this court, my lord, if your lordship see the order of this court, my lord, which says no stay.
In my review petition, I am not saying anything.
Mr. Ansariya, we have not stayed the arbitral award. Did I utter one sentence saying the arbitral award?
I never even asked for it.
Lordship would see, my lord. Lordship would see.
You need only to say, go through that judgment in 1958 Supreme Court. You'll get the answer.
I'm so sorry, my lord.
1958 Supreme Court, you will get the answer. If there is no stay, what can be, whether any order can be executed.
What I'm saying.
Specifically dealt with by this.
Lords are exercising review jurisdiction. Lord, for 5 years, my lord, they don't
Mr.
deposit
Ansariya,
money
Mr.
decree, my
Ansariya,
lord.
You immediately execute it.
My lord, that's what I'm saying, my lord. My lord, again, my lord,
The High Court, Mr. Hansaria,
Yes.
the High Court, 1 second. The High Court.
High Court has initially-
1 second.
Yes.
The High Court, out of deference and respect for the pendency of the proceedings before this court,
Yes, my lord.
did not feel that it would be appropriate to start execution.
Yes, my lord.
Now that we have concluded these proceedings,
Yes.
there's no bar at all on your filing an execution.
Your lordship said, my lord, lordship would observe there is no stay, my lord, and they.
But we have to clarify, sir. Thank you.
Very well, I'll leave it. Please, your lordships.
I seek my lord's indulgence to mention a matter, Lordship. This is this Vidarbha MERC matter, which my lords had heard it.
In 22 minutes.
22. So now only half an hour arguments are left. So it's listed tomorrow. This is Vidarbha Adani matter. So we were requesting.
But it was this bench or what was it?
No, Honorable Justice Pardiwala and your lordships heard the matter. Justice Kohli used to sit in that bench
Oh, I see.
earlier. So this has to be argued, but it's a very short issue. We've confined our
It's
submission.
on board tomorrow.
It's on board, but it's a regular list. So
What you were requesting, or if it could be heard on priority.
Like this. Let me see. Just send him an email.
Send him, send him.
All right, then I'll deal with it. Let me see how long the matter is like. All right.
My lords, I'm seeking permission to mention the,
1 second. We're wondering who is mentioning. From the screen or who's mentioning?
I will let her do it. Okay.
You're mentioning. All right.
My lords, I'm seeking permission to mention the Gram Panchayat election matter in Punjab, my lords. By way, my lords, a detailed interim order was passed on 9th of October, by which 270 petitions, a stay was granted in those petitions.
Signed it, I
The elections, my lords,
It's a
the
fresh
election.
matter.
It's a fresh matter, my lords.
It'll be listed. Don't worry. Just send an email.
My lords, the elections are today itself. We filed it in the morning. We moved the urgency. My lords, the elections are today.
Lord,
And my lords,
beseech my lords and
When was the impugned order passed?
yesterday, my lords. My lords, in fact,
So what is the interim order?
the interim order had stayed elections in 270 constituencies. The state moved the preponement application on Sunday, and it was. And the state had not even filed a reply in the main petition. By way of a preponement application, the matter was heard, and all the matters, approximately 850 matters, were dismissed without a proper hearing. And my lords, elections are happening today.
So you can challenge the result of the election now. How can we address?
Lord,
Voting must have started already.
my lord, why beseech my lords and indulgences in most of the constituencies, my lord, there is only a single candidate.
That's right.
Which has been declared. My lord, all other candidates, their
Opposition
candidature has
candidates are
been
not
rejected.
allowed at all.
My lord, absolutely.
Only the
categorically,
ruling party candidates are allowed.
My lords, we hear that they are being
What-
put behind bars.
When did the High Court dismiss the petition?
My lord,
Yesterday.
my lord, what has happened is 9th, a stay order is passed, my lord. That gets adjourned for 16th, my lord, in order for the state to file a reply. My lord, the state, rather than filing a reply, moves an application for preponement on Monday. My lord, on the same day, my lord, those preponement applications are allowed. The fresh matters, which were around 700, and the previous 270
When is the
matters.
judgment of the High Court?
My lord,
My lords, it's not even up. The state.
That will take 3 days. That was pronounced.
my lord, the interim we have, in the interim, my lord, the honorable.
Where is the judgment?
My lords, it's not been uploaded.
No, but tell us one thing. Initially, the High Court stayed the election.
Yes, my lords, by way of 46-page judgment.
The state moved an application for preponement. They hear the application and they vacate the stay and dismiss the petition.
That's right.
As a result of which the elections are to take place today.
That's right.
Now, when has counting begun today?
When it's
Not
Counting
at
is
10.
to begin tomorrow.
No. Sorry, I mean, when is the polling? When did the polling begin?
Polling has started at 8, my lords.
So once polling has started today, how can we interfere today at this?
But my lords, look at the way this is
It would be
happening.
very improper for us. In fact, probably the High Court realized the gravity of its order and therefore vacated the
My
stay.
lords, one bench had stayed the matter, and on the another bench, it was listed for the purpose of vacation of stay, my lords, without considering the previous order and without hearing us.
The first order was passed by whom?
Mr. Justice Sandeep Modgi's bench, my lords. And
That was a vacation bench, my
yesterday, that was the vacation bench when we had got listed the matter.
You got the stay before a vacation. Day.
Vacation.
In the puja vacation.
Please, my lords.
Right. Then
And my lords, yesterday, my lords,
the
the
regular bench took it up.
regular bench took it up
That's
without.
perfectly fine. A regular bench can always take up a matter after it's listed after the short vacation.
Vacation bench had decided the issue of maintainability,
That's-
even decided the issue of 243 ohm lot.
And listed
Lord,
it for
without-
16th of October, my lords.
Without there being any change
Anyway,
in
but now,
circumstances, my lord.
anyway, now that the polling has opened, we can suppose we stay. There'll be chaos. There'll be complete chaos.
My
Hello,
lord,
the declaration may be
Results, my
stayed.
lords, can be stayed.
technically, my lord, at least that can be stayed, my lord. Since my lord would.
The matter will be listed, but we'll not pass any interim order like this.
Lord,
In any case, we have not read the papers. We don't have the benefit of the judgment, and for us to pass an order staying the conduct of an election is a very, very serious thing.
Lord,
We will not do anything of the kind.
it is an unusual case, my lord, but it is an unusual circumstance also, my
But
lord.
it's an unusual democracy also, where we value elections in the democracy. Court should not be staying elections.
Lord, where
But my
one-
You have your remedies in an
Now-
election. You have your remedies in an election petition. We will not stay. We will not stay. And least of all, once polling is opened, You realize the gravity of what you are asking?
Where the ruling party tears out the number.
Or if somebody says that stay a parliamentary election or a state legislative election after polling is open, can you imagine the consequences?
The only consideration the
My
High
lords,
Court
the
has taken
counting
is.
part, my lords, had given indulgence in the mayor elections of Chandigarh, my lords. The counting part, my lords.
My lord, I've seen, my lord, how they have acted in the previous cases. My lord, the only
Let me
consideration.
list the matter. We list the matter. Let it come up before the bench. The matter will be taken up, but we are not passing an interim order, right?
Please, my lord.
Lordship,
My lord, state permission. I have a simple
My
prayer
lord,
to make.
can it be listed after?
We'll see. I'll list the matter. There's no difficulty. I'll list the matter.
Lord, I have a much simpler prayer to be made. Connected matter is coming up tomorrow. My matter has been diary numbered. I'm only requesting
Before which bench?
court number 4, my lords. That's a Delhi High Court election matter.
Out of the same order.
That's, yes, my lords. The women reservation they are seeking for the one SLP is listed tomorrow. I want this as
That is before Justice Honorable Justice Surya Khan's bench.
my lords.
That's direction for inducting certain number for
Reservation for women can
women.
some post.
Surya Khan's applicant.
Very grateful.
My lords, when may the matter
mention a matter of reservation, lordships, the Christian reservation, the issue about the conversion issues, lordships.
Yes, right.
Conversion issues,
Send an
lordships,
email. These are not urgent matters. These are separate.
lordships. It is not about listing, lordships, if I may humbly submit. The special bench led by Honorable Justice Pardiwala, lordships, in that time had been granted to the state to file the written submissions.
Yes.
Lordships, the state is seeking, if lordships will permit some more time, since the roles of each accused,
Till
lordships.
when do you want an extension, my
Till
lord?
Monday,
Otherwise-
lordships. Was the order, lordships.
No, but how long do you want to file?
Just
for
till Monday, lordships. Deeply obliged, lordships.
My lords, the listing may be allowed for tomorrow.
You can't have a choice of days. That's the prerogative of the Chief Justice. Now you argue, I'll decide on the date. Yes.
Deeply
Lord,
obliged.
yesterday I had the freebies matter. My lord had directed Mr. Khansaria to.
Yeah.
This is item 10.
My lord, it is
We'll take a call. Just circulate an email.
It's already done, my lord.
All right,
the Lordship's
take a-
permission. May I mention, my lords? Because I've circulated an email. The only reason I'm mentioning is I want the listing on Friday because it's a child custody matter. For 5 years,
You said that in your email, right? Why do you presume that I'll not look at the email?
No, my lords.
Child
What do you
custody
think?
matter, you filed the matter. It's a fresh matter.
It's a fresh matter, my lords.
Don't
Because
worry.
I wanted listed for Friday, my lords. That's the only reason why I'm mentioning.
Take an email, we'll do it. I'll take child custody matter.
Fresh petition for application for postgraduate courses with the National Medical Council. The portal closes on 17th of October. It's an extremely urgent matter. I've circulated the email.
It'll be then. Why?
Seeking your indulgence. Thank you.
That's
Lordship, if my lordship may permit me, this is
appearing for Mr. Chandrapal. Chandrapal, my lords.
You are appearing for him? Is he your client or is your
No,
counsel?
he's an advocate. He's my senior, my lords. So sorry.
Then you're not appearing for him, but with him. Yes, Mr. Chandrapal. Yeah. go ahead.
Lordship, this is a very slightly serious matter. This regards the COVID-19 stay order, which was there in a suo motu petition by this court in SMCWP 3 of 2020.
After notice matter.
And the NPA calculations as well as the interest calculations of my
ये fresh matter है या after notice matter है?
and the matter is put up for of property, and the DRT would be requiring a clarification as to whether DRT is also covered by that particular order.
So we'll ask his junior, is it a fresh matter and after notice matter?
My lords, this matter was on of 2022, my lords. However,
So it's dismissed or what is it?
my lords, it is still pending, my lords.
Is it after notice?
It is after notice, my lord.
Circulate an email. I'll see what to do on that. Just tell him to circulate an email.
Okay.
Yes. Sure. One. Presented. This returnable in 4 weeks. Pending further orders. No. Take a breath. Pending further orders, no coercive steps shall be taken against the petitioner on the basis of the order of the Foreigners Tribunal dated 11 December 2019 or the impugned order of the High Court. Liberty to serve the respondents, liberty to serve the Union of India through the central agency, the Standing Council for the State of Assam. Item 2.
Your Lordship, on the last occasion, suggested to the State Council whether it could be possible for them to take a call, whether it could be implemented from, the amended rule can be implemented from next year, so that, my lords, all equities are sorted out. And since the rule had come midway after the exam had started, the Lord asked them to take a call on that.
Appearing for the state now?
Your Lordships would recall on the last occasion, we had said that we will put on notice all the caveators because that concession that had been made on our behalf.
You wanted to withdraw that?
Yes. So we had, in fact, on the same day sent an email to all of them. We also put out public notices in Hyderabad.
Well, that's one aspect. But what about the aspect about making it applicable?
As a council, because your Lordship had asked me to, I had tried my best to convince them, but the state administratively. Give me what are you going to hand up? Yes. This is my copy. Come on. Same thing. Forget all these compliances.
Can recall the concession.
We are. I'll just three things that I wanted to say.
Can we do this? We have a part heard today because this will take time. We'll take it up on Friday.
My lord, we have some improvements as well in item 30.
It'll just take 2 minutes. Just 2 minutes from my end. That's all I have to say. Three things. The first, that we put all of them on notice. We put up public notices also. So I presume the caveators are here today. The ones who benefited from the concession.
Yes.
Second, the counselling is over. We find that 84 of them to whom the concession was granted are those who have qualified and been tentatively have succeeded in the counselling sessions. But they have all been put on notice that this is subject to the outcome of whatever takes place here. Because we made it clear that the concession then is in the balance rather than being unequivocal. So that we have done, and we have a list here of what the process is and how many are in the state quota.
There's two factors we place on Friday.
Third, which I was asked as a council to try and ask them whether they could, courtesy what Mr. Suresh said last time. I'm sorry. Can I just was that try and convince them to try and push this to be effective from next year. Yes. We have had extensive conferences. They say that they are not in a position to do that because it will cause kind of domino effect. So they're saying that's not something they're comfortable doing. Withdrawing the concession is what the state has very clearly said.
Have you filed an application for withdrawal of the concession?
No, not a formal application has not been filed for withdrawing. That came during the hearing, so.
Lord, may I just bring two facts to your notice?
Some students have joined.
A part of that beneficiaries. Lord, Lord, may I just bring two facts to your Lordship's notice? Lord, I was a caveator on the first day when the concession was a qualified concession given only in respect of 135 petitioners who were before the court. But what has happened now is, my Lord, the admissions have been completed, classes started yesterday. Yes, but I represent 35 students who have been granted admission pursuant to the concession made. They have not opted for admission in any other course. They have now joined, my Lord, the courses in Telangana. If the concession were to be withdrawn at this particular point of time, it may visit us with very harsh consequences. Your Lordships made a clean distinction. Why the concession was limited only to the writ petitioners was only 135 petitioners went to the High Court challenging, my Lord, the amended rule. The other petitioners, I'm not arguing against them. My Lord, if the state wants to consider their case, I don't want to come in the way. But my Lord, now that because the other students are coming, having not gone before the High Court, if the concession were permitted to be withdrawn, my Lord, it will be very harsh on us because classes have also started. We have joined the courses. The other states are not waiting, my Lord, to see this controversy through, my Lord. So there also the admissions are complete. All the states have closed admissions. May I just submit?
Let me just complete. My Lord, I will not now get admission in any other course, and these are meritorious students, my Lord, who, having, my Lord, competed against all the other candidates, have got seats. Classes have begun now. Classes have begun yesterday. And I'm told, my Lord, my information is counselling completed, only 5 seats are left today.
I have irrespective of the concession, just finally one second. Irrespective of the concession, your lordships will need to balance the equities in this case. There's a lot to be, the state has to answer. They had said 16 rounds of counselling on the last to last hearing, and today they are saying the counselling is over. So, your lordships will need to balance the equities. We are left with nowhere. We are only in the 15% national quota. Your lordships want to list it on another day, no difficulty. But my laws will need to balance equities of everybody.
Counselling is going on. Second round of counselling is going on. The thing is, students have already joined. It's dramatic for them to come out.
We will just hear the matter.
Very well.
We list it next Monday.
Very well.
Yes, and we'll hear the matter.
Very well.
I have a slightly difficult problem. I have a slight.
It's a challenge to their policy, which prescribes a domicile requirement of the last 4 years of education.
That's correct.
So what we'll have to do is now revoking that concession will not protect anybody because that will not benefit anybody.
Right. That is correct.
Right. So instead of revoking the concession,
correct,
we will simply say that let the matter be placed on a non-miscellaneous day.
Very well.
It can be heard.
Yes.
Much better.
Just one submission, Millard, in this matter.
The petition
Yes,
was placed on.
Millard, I have 30 seconds only, Millard. Millard, I have a slightly difficult problem, Millard, in this matter. Despite the Millard, my lord's order, Millard, there is a IA Millard filed immediately, Millard. I have been qualified, Millard. I got much more mark, Millard, 463. I was not allowed, Millard, for the counselling process also.
That you can pursue your petition.
That's what I'm saying, Millard, subject to...
You move the High Court because we don't want to take up individual petitions.
No, Millard, I'm a petitioner before the High Court.
Oh.
I'm a petitioner before the High Court. I'm protected by this order, Millard, the first order passed by me, my lords, Millard, because of the concession. I was, Millard, not allowed to for the counselling, Millard. Today is the last date. Today is the last date.
That's an individual grievance. How can we start?
I just clarify. The concession which was extended to the petitioners. When we went through it, we found 6 people. Yes.
Out of 135.
Yes.
If we give the benefit of concession.
Yes.
Actually, all 135 will be included.
Yes. Correct.
But if we have understood you correctly.
Yes.
Out of 135, 84 have made it on their own.
Yes.
Irrespective whether concession.
No, only because of the concession. Only because of the concession.
To say 84, all 135.
No, eventually, depending on marks, who participated and eligibility, my friend's issue perhaps, I don't know who he is, but it's perhaps the fact that he was already registered as a domicile of Andhra. And therefore, there were 6 individuals that even though they would have been covered by the concession, we couldn't grant it to them because they were registered as domiciles. And
so just examine his case.
Exactly, that's what I'm saying.
Anyway, he'll expand. We'll examine your case.
Millard, I number is 22805. Could it be next week, my lord? Could it be next week? Millard, IA number is 228053.
You have a copy?
Millard, IA number is 8. Yes,
give a copy to me.
You're not going to make a record of I number.
Millard, my only submission, let it be today is the last date, Millard. Because this
I'll take a look at the IA. I'll post it.
Shankar see if can be sorted out. If there's some mistake at your level, then you have to sort it out. Otherwise, if it was registered
I'll take the IA from him.
May I make one submission? The counselling is likely to go on up till 19th as per the notified schedule of NEET, without affecting the clients of any of the senior counsel who have appeared for caveators. If the non-petitioners before the High Court would be considered independent of the concession, without affecting them.
So that we will not do. Because, unless we strike down the policy, we can't say that. And the policy prima facie, actually the whole problem arose because of the concession. Otherwise, the policy is really governed by several judgments of our court. The problem was that they made that concession and therefore others felt, look, we are better off.
Yes. Those judgments in the context of Andhra Telangana may not apply at all, Miloj, because the whole movement between Andhra Telangana is not something
What we'll do is we'll hear the matter. We'll have to hear the matter.
That's right. And laws will consider next week if possible. Definitely, given the nature.
Very well.
Always.
Millard, the last date, I'll put my friend Millard, my
item 3.
I'm ready.
No.
Item 3 is appearing.
Yes, Millard, I appear for respondent.
Are you both agreeable to an
objection? I cannot have an objection because I took a Section 8 objection in a civil suit filed with them. There's one development I'd like to point out.
Yes.
When the petition was filed before this court for seeking to appoint an arbitral tribunal, the amount was around 9 crore or something that they were claiming. But now there have been some settlement talks, some minutes, and the amount is only about 70 lakhs left. So if my learned friend is agreeable to it, we can have it resolved after a couple of weeks. Your lordship may keep it.
We'll just appoint an arbitrator. In the meantime, you can try and...
Very well.
How much is the amount now?
According to me, there were certain minutes executed post the filing of the petition. Certain issues have been settled, but there are several issues. I'm not sure whether the amount is 70 lakhs.
Email addressed to us says $72,000 now.
So why don't you, we can refer it to arbitration?
Very well.
Plus, if we are able to resolve before it, nothing like it.
Right. We say that in view of the arbitration agreement between the parties, our parties are referred to arbitration under the auspices of the Delhi International Arbitration Center.
Very DIAC, yes, Delhi International Arbitration Center.
Yes.
Oh, I'm
grateful.
Appearance note.
Please.
Yes.
And in this matter, this application is by virtue of an agreement executed in 2019. My claim is on account of the money retained by the respondent because they...
We've seen that, about 16 crores and odd.
Yes.
There was a tripartite agreement with the homeowners and all that. Now, tell us one thing, we can appoint an arbitrator?
Your Lordship, the same issue, same party, same other...
Oh, that is already gone to the tribunal of Mr. Kamal Narayan and two other people.
In fact, the award has been reserved. In fact, the point about whether it is an international commercial arbitration also taken up, decided against them, High Court petition.
And you have participated, they have participated in the
award reserved.
Yes, my lord, I'll just explain the difference. That is my entire claim of 125 crore under the agreement tender dated 2011. Now, the issues have been framed general, whether I am entitled to claim.
But in the arbitration before Mr. Narayan, you are the claimant?
Yes, I am the claimant. Now, what I am submitting.
But then how can you claim, how can you pursue this petition then?
No, my lord, I'll just explain. Because in this agreement, it was agreed that a committee will be appointed who will decide who will be the responsible, either DMRC or me, for the damage of the houses. Now, if that aspect has been taken, considered by the arbitral tribunal, I'm not aware because the issues framed are general.
No, but you should have raised it before that tribunal.
It is raised, same amount.
Look, you can't have a second bite at the cherry. You are a claimant in the arbitral tribe before that arbitral tribunal.
I'm submitting that they are that is general claim. Now,
you could have also made this claim there.
Yes,
it is paid.
But whether the arbitral tribunal have gone into, what I am submitting is that if this can
say that the petitioner, you are there the claimants, right?
Yeah, I'm the respondent.
No, in that arbitration.
Yes, he's the claimant.
I'm the claimant.
Would you like to withdraw this and pursue all your remedies in that arbitration?
Award reserved in that.
Award is reserved. What I am submitting.
Then that's it now.
No, my lord, what I am submitting is if this can.
The petitioner, admittedly, is a claimant before an arbitral tribunal seeking a refund of approximately rupees
16.70 crores.
70 crores from the respondent. Full stop. In view of the award has been reserved. Full stop. In that view of the matter, the arbitration petition, which has been filed at the behest of the petitioner, would not be maintainable since the claims form the subject matter of an earlier arbitration.
Only my respective.
Full stop. The arbitration petition is listed.
That's in case the arbitral tribunal doesn't consider this aspect.
Challenge that award
then liberty should be granted to me to come.
Yes. To take your remedies under 34 then. Item 5.
Please oblige.
Item 5.
Well, 1.87 is the value of the commercial unit from which 1.78.
So we'll have to appoint an arbitrator here.
Well, the conflict remains for an amount of rupees 26 lakhs rupees. That's all. They are not coming forward to clear the dues and accept the possession.
That may not be correct, Manoj. That may not be correct. It's around 3.
Same orders in the first matter. We'll send it to the Delhi International Arbitration Center, auspiciate of the DIAC.
Okay.
I'm seeking a short passage in this matter.
Who are you preparing for?
Sukunal Tandon.
No, not petitioner or respondent. What's about who is appearing for the respondent?
Item 6, I am appearing.
An arbitrator has to be appointed? How much is the claim? What is the claim, ma'am?
Not the total amount would be nearly 7 crore, including the counterclaim.
You are for the respondent.
I am appearing for the.
There is an arbitration agreement.
There is an arbitration.
So we'll appoint an arbitrator, 7.5 crores.
And Lord, this is a Bombay seated arbitration.
It's the Mumbai seated arbitration. Should we appoint a retired judge or should we appoint whom should we appoint?
But I think a council would be better.
A council would be better, right?
Lords, I request a pass over. I have limited.
We are allowing your petition. We are appointing an arbitrator. इसके बारे में आते हैं बॉम्बे में बहुत साल हो गए. Your council is available online, I think.
That's the proxy council. Is it?
Sorry?
Proxy council.
45 proxy council. You will get the order. Let me also find out from somebody who has found it.
So the main council is appearing through these.
Who's appearing? Where is he?
Please, my lord, I appear, my lord.
Yes, so Mr. Tandon, we'll appoint an arbitrator.
Yes, my lord.
So we'll appoint some council in Mumbai. Give us some 3-4 names, both of you.
My lord, we'll give it, my lord. I'll pass on a list.
Tell us right now. All right.
My lord, right now, I wouldn't have the names.
We'll appoint an arbitrator and by the afternoon, I'll just find out and we'll appoint some. Because the claim is 7 crores, no point in appointing a retired judge.
Claim and counterclaim both is 7 crore.
Oh, totally it's 7 crores. We'll find out somebody and it's Mumbai seated, right? We'll pass an order.
Very well, my lord. I'm so grateful, my lord.
I'm blank, Chodlo.
Lord, all objections may be.
Yes, yes.
Item 7. May I please, Lordship, arbitrator has to be appointed. It's an international commercial arbitration, so your Lordship will have to appoint an arbitrator in this. Service is complete.
Service is complete?
Yes, Lordship. We had sent an email last time because the party is based in US, so we had to send an email because no other means were being served. So email has been sent. The office report says that.
How much is the claim?
About 51 crores, your Lordship.
We appoint a arbitrator.
The clause said 3 arbitrators, but your Lordship will have to, I leave it to your Lordship. Soul would be also okay.
What's real arbitrator?
The seat is Delhi. The seat is Delhi, your Lordship.
Yeah. Delhi International Arbitration Center.
Grateful, your Lordship.
Item 8, the petitioner has failed to pay the fee for issuance of notice.
We paid the process fee in April, my lords. The service report is awaited as per the law.
All right, service is awaited.
Yes, means.
Place it after 4 weeks.
Obliged.
Item 9. I'm led by Mr. Nakul Diwan in this matter. He's in some difficulty today. I'm requesting for a short adjournment.
All right. Keep it up 2 weeks.
Item 10.
By 10 is job, but उसके पहले there are some fresh matters, no? कौन सा है?
Item 43.
Okay, 41, 42 is a fresh matter, but that has to be tagged, I think.
40 is the UP teachers matter.
That has to be tagged, no?
Well, 40 is the main matter listed today.
And which is the matter, which is a fresh matter?
I believe my list says 41. I could be wrong, but it says
the fresh matters are?
40 also indicated first matter. 40 is 40 said first teachers matter.
So we'll not start it right now. 41 and 42 have to be tagged with 40. That's all that we want to check. Now, there's only one other fresh matter, 43. Is anybody here for 40? Take it, Jetaways will start.
Well, it's 40, your lordship should take on another day after.
Take it, yes.
But this was actually your lordship's order said first.
No, but we have a partner going on.
Really unenvious job, Malad, I can see that. But wherever, Malad, we have a.
Would your lordship consider having it in the Tuesday after Deepavali, Malad?
Malad, high up.
As Tuesday after Deepavali, if possible.
It says first 2 matters. Could that be?
This is in the first line.
First to
My lord,
oblige.
the matters wherein notices have not been issued, kindly issue notice in item 40.
Same issue, Malad, we're all here. We're all here.
Same issue.
Otherwise, it'll get delayed further.
No, it will just get delayed. Whatever other, everybody is here now. The state is here. Everybody.
We have to serve upon the respondent. So
Who are the respondents?
respondent is state of you.
All of us.
They're all here. The state is here.
It is here. Ms. Bhatti is appearing for the state.
Common issue.
We can just give them the paper book.
All right.
Should be skipping
Oblige.
excuse
We'll start there. We'll start the part heard.
Oblige.
Very well. Very well.
We'll just come back in 2 minutes.
Yes, certainly.
Except for Jet. Jet will go on till lunch or we'll finish by about.
It won't finish. No, it may not even finish by now.
All right.
It is very factual, Lord. I have to know.
All right. We'll just come back in 2 minutes.
That's
Lunch.
Yes, yes.
So I apologize, my Lordship called out item 43.
Yes.
That was a fresh matter, but I'm so sorry. I was not here.
We'll just take it a little later. Let us
Very, very.